It's 10 o'clock on the dot. Let's go ahead and get started. Let's start with A, Governing Body, July Parks and Rec Month. Tracy Ivy.
Good morning, Mayor and Council. Mayor Pro Tem and Council. Tracy Ivy, Parks and Recreation Director. The purpose of me being here this morning and my team behind me is to present the proclamation supporting the city's participation in the National Recreation and Park Association's Parks and Recreation Month to showcase and celebrate the city and the many services it provides. Each July, we celebrate park and recreation professionals and how they improve the lives of tens of millions of people, making a lasting impact in communities across the country. Park and recreation programs are essential to community health and well-being and help cultivate lifelong friendships, memories, and family bonds that people hold dear decades later. This year's theme, Build Together, Play Together, reminds us of the contributions of more than 160,000 full-time park and recreation professionals, along with hundreds of thousands of part-time and seasonal workers and volunteers who maintain our country's close-to-home parks. Together, we're building and maintaining sustainable parks and green spaces for current and future generations. Together, we're building thriving communities focused on health and well-being. Together, we're building high-quality programs and spaces accessible and inclusive for all. Together, we help people play and connect through yoga, art, picnics, and more. My recommendation today is to proclaim that July 2025 is Parks and Recreation Month in the city of Rica. But before you make a motion, I'd like to make a few other comments. And before you read the proclamation. Oh, that's true. Good. There you go. That's why I'm in recreation and you're... I want to take a few moments to speak from the heart, specifically to recognize the many contributions of our staff and others who we sometimes forget to thank. Many of our recreation team is present this morning, including our administration team, athletic programs and maintenance crews, recreation programmers, senior center staff, seasonal and part-time staff, and class instructors. The collective efforts of the recreation department and its staff span over several decades. And when I say staff, I'm referring to the individuals who each play a vital role in making the department run days, nights, holidays, and weekends. Just last month, the city recognized Ms. Tara Ivy for her 25 years of service. I would also like to thank Barry, some of you know Barry as Bear Evans, for his 25 years of service, all part-time. You both really gotta love it. And I think Barry does it because his wife probably doesn't want him at home. Gotta be something. I know you, Bear. Other employees' tenure ranges with some as few as a couple of years or less. I am grateful for all your contributions as each one of you brings a certain value to completing our team. I want to recognize Ms. Deborah Kleckler and Ms. Gretchen House, instructors who for over 20 years have each provided countless hours of instruction to hundreds of individuals in their classes. We have much newer instructors who are also making strides doing what they love, and I appreciate all of your energy and dedication as well. We recently welcomed Miss Amberly Nally, a local who was raised on the gymnastics mat, taught youth for many years at the rec, opened her own successful gymnastics center, and has now returned after over 20 years. We're excited to see you and your team joining our team and continuing to teach local youngsters the art of acrobatics and for entrusting in us that this teamwork will work. To the many volunteers who join us every year, you are equally vital to the success and growth of our youth. You spend hours away from homes and sometimes your own families. You run straight to the park right after work for a 6 o'clock game or practice. You build game lineups and set up team practices, spend money out of your own pockets. Thank you for all your thankless contributions every season. No matter what individual role you may play, you are part of a great team, one person the extension of the other. I want to thank you all for what you do, and I am grateful to have the opportunity to recognize you today. Finally, all of us, we can't forget to thank the City Council for giving us the tools and resources to get our jobs done while serving the citizens of Villa Rica. And thanks continue to many other staff who support us daily. We could not deliver this without your support. Thank you.
Let's see here. Give me just a second to download it. Okay. Okay. I get the pleasure today of reading the proclamation. So, Proclamation of July as Park and Recreation Month. Whereas parks and recreation programs are an integral part of communities throughout this country, including the city of Villa Rica. Whereas our parks and recreation are vitally important to establishing and maintaining the quality of life in our communities, ensuring the health of all citizens and contributing to the economic and environmental well-being of a community and region. Whereas parks and recreation programs build healthy, active communities that aid in the prevention of chronic disease, provide therapeutic recreation services for those who are mentally or physically disabled, and also improve the mental and emotional health of all citizens. Parks and recreation programs increase a community's economic prosperity through increased property value, expansion of the local tax base, increased tourism, the attraction and retention of businesses, and crime reduction. Parks and recreation areas are fundamental to the environment well-being of our community. Parks and natural recreation areas improve water quality, protect groundwater, prevent flooding, improve the quality of the air we breathe, provide vegetative buffers to development, and produce habitat for wildlife. Our parks and natural recreation areas ensure the ecological beauty of our community and provide a place for children and adults to connect with nature and recreate outdoors. The U.S. House of Representatives has designated July as Parks and Recreation Month. The City of Villa Rica recognizes the benefits derived from parks and recreation resources. Now, thereof be it resolved that July 2025 be designated as Park and Recreation Month in the City of Villa Rica.
You gonna get the picture?
Number one.
You got to get the picture made.
Who, what?
The picture. That's a part of your duty.
All right, moving along. A2, discussion of ethics ordinance.
All right. This is just a discussion item, and what I really need from council is some guidance on what you guys want the ethics ordinance to look like, so I can go that direction. And I'll back up a little bit. You know, we received the first document. They called itself an ethics complaint earlier this year. It didn't really satisfy what we consider a complaint under the ethics ordinance. It was not submitted under oath, and it's not an ethics complaint until you submit a document under oath. So we went through that process. The council did follow the ethics ordinance as it's currently set out, filled the positions on that board. That board has worked hard. They've had 4 or 5 meetings or more. One of the first orders of business was they looked at the complaint and trying to match the complaint with what was alleged in the complaint and the ordinance was a difficult task because it was kind of all over the place. And so they adopted a complaint form that would make it easier to just evaluate complaints as they come in. And all they did was take each ethics ordinance, each thing that our ordinance says is an ethics violation, lists it out and says, is this what you're saying this person did? Tell us why, and tell us who your witnesses or the evidence are that this person committed this ethics violation. So if someone filled out that form completely, that would make it a whole lot easier, one, just to figure out what are they complaining about. Because it took a lot of time, honestly, to just figure out what exactly are they saying that we understand that they're complaining, that they are upset about what this person did. They've got a general grievance. But what about that general grievance is an actual ethics ordinance? And that took a lot of effort. And the hope was that complaint form would at least make that process easier. So we know right off the bat, okay, this person's saying this person violated section 2103 because they accepted money from an applicant and then voted on it. I mean, we know what they're complaining about. The problem is, now we've accepted some more complaints where they've used our complaint form and they say, see attached. And the attached is exactly what we were dealing with the first time, where it's all over the place. And we're trying to plug in, or the board's going to have to try to plug in to see what they're claiming. So I imagine the board may send those complaints back, say, fill out the complaint, fill out the form that we're requiring you to fill out. But I don't know. I mean, the board will have to make that decision. So that's one thing they did that I thought was good. They at least came out with a form that would help with the process. The second thing they did was they came up with procedures, and I think everyone recognized this is the first time we're dealing with this, so these procedures may need to change, but at least gave a process of dealing with the complaint. And so those two things, I think, were very good steps. They took their job serious. They went through the process, and I think they issued their recommendation to the council following the hearing that they held. I think based on that experience, they'll probably make some changes to their procedures just because they've been through it, and it's not just on paper, but it's real life, so they've experienced it, and they might want to tweak some things. But that's where we are. I think the first time I had a conversation in front of you guys about the ethics ordinance, and I think in every conversation since then, my biggest issue was the way the board was set up. That it just gave, whether these people are as perfect as we can get, just the impression is they're being picked by the people that the complaints are being made of, and so that just doesn't give an impression or the feeling to the person making the complaint that their complaint's being treated seriously. So that's always been one of my issues. I don't know if y'all share that, but I think you do. And then there's been other discussions that, you know, what's the purpose of the ethics board? Because at the end of the day, they can't do much. GMA's the one that recommends you adopt an ethics ordinance, become a city of ethics, and in their brochure, it even says that they question whether ethics boards can even impose fines legally. I mean, they clearly agree they can't force people out of office. That would have to go through a different process. And you've got other avenues of relief typically for a real ethics violation. I mean, there's probably a civil lawsuit that you can file in Superior Court, or another board somewhere out there that could hear whatever. If it's a real ethics complaint, they could hear that. So, the next question was, do we even need an ethics board, because there's other avenues of relief? I can tell you, I just told you that this ethics board met 5 or 6 times, held a hearing. We used up city resources to do that. I mean, I can't tell you a dollar figure, but there's a cost to it, to the city and to the taxpayers. In that case, the person that made the complaint also filed a lawsuit in Douglas County. Typically, lawsuits against the city are filed in Carroll County because that's where you guys meet. That's where City Hall is. So we've had to deal with that. That costs the taxpayers and city a lot of money. So what I need, and I think the discussion we need to have is, do we want to keep the ethics complaint, our ethics ordinance that we have, and tweak it? Do we want to do away with it, or some other combination? And I think, I mean, you can go any direction. No matter what direction you go, you're not going to take away from the people their right to address true ethic violations. They had that before we had an ethics ordinance. They'll have it whether we have one or not. You know, the fact that we have an ethics ordinance, if you go to strike it, of course, you know, that's going to be interpreted however it's going to be interpreted. It's going to, I'm sure people will say you're doing away with that, so people won't have the ability to make complaints against you. That's just simply not the case, but that's how it's going to be interpreted by some and probably reported by some. So I think we should have a short discussion, or y'all can reach out to me later. But we did have a 60-day moratorium. That 60 days has expired, so we're back to complaints were being filed. If it'd been like the previous 20 years, we wouldn't be having this conversation. It's not like the last 20 years. People, as I've said before, this process is subject to abuse. I mean, someone, if they want to just use it as a method of harassing, they can. Currently, our ordinance has no penalty really for doing that. There are other ethics ordinances that would allow attorney fees to be awarded if someone made a frivolous complaint. There are some that would impose monetary penalties if someone made a frivolous complaint. You know, if someone makes a complaint against you and you take it seriously, you have every right to hire an attorney, and there's no telling what that would cost you personally. And if it's a frivolous complaint, I would imagine you want the ability to be reimbursed for that. And right now, our ordinance doesn't really allow that. I can give you some examples of some other cities, how their boards are made up, if you want that. I think we talked about that at our work session at one point. There are a number of cities that have the exact same ordinance that we have. There are others that make up the third person's an attorney. That was when I went back and looked at the history of our ordinance, that was one of the initial proposals, but at that time there weren't it was going to require all members on that board to be residents of Villa Rica, and there weren't really enough practicing attorneys in Villa Rica at that time to make that work. That may have changed. I don't know how many practicing attorneys are in Villa Rica, or if you would even have to require them to be in Villa Rica. I'm not saying you need to be an attorney to be on this board, but that's what some cities do. It does make sense that an attorney is available for the board because they do have questions. Whether that needs to be the city attorney or some other separate attorney, that's another question that I think we need to talk about. In some cities, like in Douglasville, you cannot file a complaint unless it's filed with an attorney. I don't know if that's ever been challenged, but typically, if we were in the civil arena in the court systems, every citizen has a right to represent themselves in court. You don't have to have an attorney. So it seems like that's probably subject to challenge. But we do have what I would call a frivolity review process in the ordinance, where they review the ordinance initially to say, are they even making a complaint? And if not, then that could end the process right there. But that does require them to get together and review the complaint. And so at this point, I just need direction from the council. Do we want to keep what we got as it is? Do we want to keep what we got and make some changes? Or do we want to go a different direction?
Okay, I'm going to first open up. I'm going to try to do this orderly since I'm kind of new at this. This time I'm going to start at Matthew. Does anyone have any questions for Kevin?
I don't have any questions, but when we get to discussion, I might have some discussion. Thank you.
Shirley, you have a question?
No.
Danny,
I
Stephanie?
had one question. You said the moratorium, has it already expired?
I think it just expired.
We're at 68 days.
It was when?
68 days. Sorry, the moratorium was for 60 days. It was on March 27th when you had the special call meeting, and I believe today is the 68th day. Yesterday was 67. I counted it out.
Okay, thank you.
Stephanie?
So as of right now, any complaints that come in, just for clarification purposes, would go under our current ordinance, correct?
That's
Okay.
correct.
Now, how at a state level are complaints handled?
It depends on what the nature of the offense is. So if it's, it could be a criminal offense, more than likely. I mean, most true ethics complaints are probably in violation of some criminal statute. The most obvious is someone paid you for a vote. I mean, that'd be a bribery charge. We don't see that very often, but that would clearly be an offense. Conflicts of interest, where if you had financial interest in something you voted on, that could be, that would violate several criminal ordinances, as well as someone could file a civil lawsuit to set aside. Let's say you approved a contract and you had some financial interest in it. Someone can file a civil lawsuit to set that contract aside. So they actually would get real relief by filing a civil lawsuit. If they file an ethics complaint, you might get reprimanded for that conduct. But there would be no real relief to the city, if that makes sense. There are ethics violations for financial disclosures for any elected official. Those are under a whole set of ordinances, statutes. There's open records and open meetings, statutes that would apply. So they're all over the place, so it just depends. It's hard to answer that without knowing specifically what conduct you're complaining about. But just about anything that we would say is a true ethics ordinance would also have some civil or criminal pathway other than through this ethics board.
So at a state level, they would receive a true resolution.
Right. State or county level.
Because as city entity, there's not any real, as we've said, any real teeth.
Not
To-
for the Board of Ethics.
Okay?
That's right.
So I guess I'm trying to understand. My questions are pertaining more to the purpose of actually having this ethics board in general. At least at a city level, let me say that. Because there is nothing, there's no real consequences to any sort of wrongdoing. But even the complaints that have no real ground, no leg to stand on, what is there at a state level, is there something that someone who is filing complaints that have no real ground, or is there any kind of repercussions for that?
Not typically. I mean, if it's a criminal complaint, then yes, you're going to have a prosecutor's office somewhere. They're going to make that decision whether there's enough to take it before a grand jury or file an accusation. If on the civil arena, and we see it every day. I mean, anybody can sue anybody for just about anything, and there's not a good pre-lawsuit method in state court for weeding those out. There are processes once you're in court, penalties, attorney fees for filing something frivolous. There's some teeth there to hopefully discourage frivolous lawsuits. In federal court, there is a review. The federal magistrate judges will review to see if it's clearly frivolous. A lot of times they'll dismiss it before you know you've even been sued. But on the state level, we don't see that.
Okay.
Okay, I'm going to open up for discussion. So I'll start on this side again. Does anybody have any comments for discussion?
Well, as someone who officially, as of yesterday, has an ethics complaint filed against me, I still want to maintain the position that I don't think we should do away with this board. I think we should probably improve it. I think that's, I understand that it's really fruitless. I understand that it's a waste of everyone's time, but, the appearance that we're not allowing the citizens to have a place to redress their grievances is not something that I believe I support. So I think we should look at how we can improve it. I think we should take some of Kevin's recommendations. Maybe we rearrange the board. Maybe each council person appoints a member to the board similar to planning and zoning. Maybe we do put some sort of pre-hearing or frivolity review in there. Maybe we put something in there to discourage frivolous complaints, something about, where the party, if it's found to be frivolous or something of that, through some sort of appeal or some other mechanism or something, they have to pay back a certain fee. Maybe we include a filing fee just to cover some of the kind of the cost associated for the city. So I think we should improve it. I don't think we should necessarily get rid of it, but that's just my perspective.
I'm only piggybacking on because that's a good segue into what I was going to say, is that I think this does give the public at least some kind of recourse, even though at the end of the day, nothing the city can do, but at least it's out there, it's public, it's transparent, and that's good for the people, in my opinion. I do agree we need to I like the idea of doing it something like planning and zoning, where we appoint our own people. My only complaint with this current iteration of it was that it felt very heavily, because it was 2-3. I didn't think it was I thought it felt very heavily toward one side or another, and it would be the same way if the mayor had no recourse, but council had 5 people. So I just think it needs to be more fair and balanced is how I look at it.
Well, I had one, yeah, I'm on. When we first started the board, did I understand that this was a temporary board to handle that particular thing, and then after that, they would get do another board?
No, well, no, we needed to fill the board initially because it just
Right,
had never
yeah.
been filled. But they are appointed at least for a year,
Okay.
unless we make some changes to it. I mean, we may make some changes in between that time frame. Yeah, to address Councilwoman McCoy's issue, I mean, the mayor just picked one. She picked one that y'all had to approve, and then y'all had to, between all of you, had to come up with someone that y'all would approve. So, the mayor's choice in the last proceedings didn't participate. So he did not participate in discussions of the complaint itself, or the actual hearing, or any votes after that. So he was recused, but so maybe that addressed that issue, but then that just left two people to do all the work. So.
And I think that was one of our, in my head, the word complaint was going to come out of my mouth, but that's not what I meant. That was one of our concerns when we all discussed it before. But if there are no other questions,
It's not really a question. I'm glad to hear you say that you gonna make sure they completely fill out the complaint form
Well,
prior to we accepting it.
Yeah, that's going to be that's what I'm going to recommend to the board. I mean, ultimately, they'll make the decision on what they do.
Does the complaint come into the city clerk? Is she the one that
They
receives
file
it?
it with the city clerk.
Yeah, I think that's the least we need to do is make sure they complete the forms. Don't just send it in with blank spots all over it. And,
I agree.
And other than that, you're not really doing anything other than giving the people a place to complain, because it has no teeth to it. There's no results from it. What happens if the board finds it as a valid complaint? Do they ship it on down to the state or what?
No, they're simply a recommending body, like planning and zoning. They would go through the process and make a recommendation to this council. Now, their recommendation would be, we recommend this person vacate their office or resign from office, or.
But that doesn't hold any teeth at all. You
No.
can't force a person out.
No, but I mean, that'd be a pretty damaging report. I mean, I would think, I think that gets picked up in all your press, and so there may be some tangential or some not direct consequences, but I think there would be some consequences with that kind of recommendation. But they don't have the authority to do anything other than make a recommendation to this board.
Okay.
Ms. Warmoth?
Okay, I am not arguing for or against this, so I'm just throwing out ideas and concerns of where it is that I'm coming from. I do agree that fair and balance is what is lacking with the way this ordinance is currently put in place for this board. I agree to set it up possibly as something like planning and zoning is. But again, it still comes back to the cost to the taxpayers and what the cost to them is going to be for, I mean, of course, if there's a legitimate complaint, then it should be looked into. But if we're talking about just complaining to complain, then it's costing taxpayers. But to that as well, it's also costing time to those board members. And if we continue to have just complaints with no real ground, then how many people are actually going to want to serve on that board if it's nothing but here we go, another 4-hour meeting where it's just complaints. So eventually, who's going to want to even serve on that kind of board? That's where my concern is for that. The fees, to apply fees for filing those complaints, number one, you're talking about financial ability to be able to file that complaint. Just because somebody may not be able to afford to file a complaint because of a fee doesn't mean that they shouldn't be heard. And if we apply any sort of fees for what would be considered by the board to not have any real ground, and we're going to apply fees to those who it's found to be have no real purpose, you're going to create fear of people afraid to file a complaint. Because if I file a complaint, I could have thousands of dollars in fees that I have to pay. So just some things to think about. Again, I am not arguing for or against. I do think that changes need to be made if we keep this board. But I think that there's just a lot of things that need to be considered if we do make changes to keep this board, or if we just decide that this isn't something that we need on a city level.
Well, Mr. Drummond, did that give you any direction?
I have absolutely no direction. No. Well, what I'm hearing is we probably want to modify what we've got, which is not as urgent. I mean, it's urgent. I mean, we need to deal with it, but it's not something I think we have to vote on tomorrow. And some of this may just be going through the process of figuring out what works and what doesn't. But I will try to come up with some ideas on the actual composition of the board that maybe it's hard to get volunteers. To your point, we've got VRDA that is about to all of those positions are about to be vacated by operation of law because we can't get volunteers. And so in my mind, what I'm thinking is maybe everybody gets appoint someone on there, but maybe that board picks 3 of the board members to hear a specific complaint or something, so that you're not tying everybody up all the time. Kind of like our Court of Appeals, they'll assign a panel to. They don't all hear every case. They divvy out the work. But at least that way, if there's a complaint against Mr. Carter, then Mr. Carter's representative doesn't have to sit through that process.
Yeah, since it ended up with just 2 members doing all the work, I think that's a wise choice. To each one of us could have a member on the board, but you could only have 3 that follow through on a complaint.
Yeah, so I can work on some drafts and circulate those and just get your feedback on which, if we're headed the right direction or wrong direction. Y'all just be honest with me about, stop wasting your time on this or
Okay.
whatever I need to do.
But if they did do a board, like they were saying, you get each council member appoint somebody on. So would it have to be somebody in that ward? Say, for instance, me, if I choose somebody, would it have to be somebody in Ward 1, or could I pick whoever I want?
I think it could either direction. It's whatever you prefer. I think it gets back to your pool of volunteers, people that are willing to give up their free time away from jobs or family or, just life is a limited pool.
Well, and you're always going to have that. You're always going to have conflict of interest. And by that, I mean, when you mention if the complaint is on a council member and that person recuses themselves that's on that board, I mean, who's to say that we wouldn't know other members on the board? That's what I mean by a conflict, because we're still in a small town.
Sure.
We still know, we know people that are in other wards. It's not like we only speak to the people in our wards. So we're in a, there's just always going to be that, well, I know them, especially when you're talking about volunteers. Like you said, the pool of volunteers is small, so most of the time we know who the volunteers are. There's always going to be some sort of issue here or there, and I think that that's one of the biggest complaints with this ethics board is, how do we make it fair? How do we make it where there isn't that appearance that we are directing or influencing that ethics board in any sort of way? Because it should be fair during any kind of investigation. But again, we're still in a small town.
Right. You know, Rome redid theirs, and they appoint a lawyer that does not live in the city or in the county. I'd have to go back. It was either Rome or Floyd County. And that's a good system, other than that's a budget item. I mean, that's to do that, you're going to have to do that at budget time, because you're going to have to, you know, that could be tens of thousands of dollars for each complaint.
See, and then we're talking about cost to the taxpayers, and is that really what the taxpayers want for their tax dollars to go to? And again, I'm sure that everybody would agree that if it is a legitimate complaint, absolutely. But if we're talking about just complaining to complain, taxpayers, I would imagine, would not want to spend tens of thousands of dollars for just a complaint just to do so.
Right.
Well, I mean, but see, I think that's where, if we kind of follow what we do in our court system model, right, you have a filing fee, and if you can't afford the filing fee, there's an application you can pay to get that filing fee waived. And then also, if it's deemed to be frivolous, according to certain statutes that we have in the court system, then, you know, and you have to reach a certain burden, like just because you lost the complaint doesn't necessarily mean that it's frivolous, right? You know, we're not necessarily a loser pay system here in Georgia. But if, you know, it lacks substantial justification, if it was for harassment or hinder and delay, and there are legal standards and all that stuff in Georgia case law, then it could rise. Then, you know, when all the factors align, those could arise to be frivolous, and that burden goes back on the person that filed it. You know, I mean, I think it's just a balance. But again, I don't want to chill or don't want to harm or slow anybody from doing it, but our current legal system has these kind of barriers, or, you know, not barriers, I should say guidelines, and to kind of keep things hopefully clean.
Okay, and if we decide to go the route of each one of us appoints a member to the board, but there are only 3 of them here with a complaint, I don't think we ought to limit it to just our ward. We ought to be able to select across the city, because just like planning and zoning, you can't always find somebody in your ward that's willing to serve. If you want to fill out the whole board, you got to pick someone outside your ward.
I almost think you need to make the pool as big as you can.
Yeah.
They either work or live, you know, either own a business or live in the city, or if you want to make sure they have a tie to this
I think it'd be wise to at least keep them inside the city, because reaching outside the city could create some problems.
All right, well, I'll work on some drafts. And
I guess I was going to say, I mean, Kevin, I mean, do you think you could come up with just different versions and just kind of send us a, hey, you know, and maybe we can take, let's say we got 3 versions, and you have, this is a version that's kind of this way, and this is a version, and then we can also maybe just take different versions and kind of, well, I like this version, but I like this language, and let's switch it out, kind of thing, maybe.
Yep.
We can talk about it.
Okay, one other thing. I think since we're working on making a change to it, I think that we should put into place another moratorium to hold off on the complaints until we get it the way it needs to be. I don't think working with a system that we don't really agree with is a good thing to go.
Well, we can just add that to Tuesday's agenda and someone make that motion Tuesday.
Okay.
Okay, any other discussion? Speak now. All right, well, that was somewhat productive. All right, moving on to A3, Planning and Zoning Appointment for Ward 1. Shirley, I'm gonna turn it over to you.
I have been informed that I have gotten a person that's interested, so we'll buzz that Tuesday.
Okay, A4, Planning and Zoning, Ward 2, Mr. Montahan.
I've reached out to my current appointment. She says she is interested in continuing to serve, and so I would like to just reappoint her.
Okay. Does anybody have a problem with making that consent number 2? Or do we have to do it in a meeting? Kevin? Okay, everybody agree to making that consent? Anybody have an issue? All right, that's consent number 2.
And that's just item 4, right?
Item 4.
Not 3. Okay.
Yeah, 3 will be Tuesday. Okay, B1. Is this, I thought this might be Nick. I don't have my glasses on, sorry. Jameson Towns, Phase 2.
Yes, ma'am. The
Final
final plat.
plat.
We're requesting approval for the final plat on phase 2.
All right.
Good morning. This is obviously the phase 2 of Jameson Towns development. It's over off of Reed Road. The developer or the current owner, Smith Douglas, has met all of the conditions set forth by the council that staff thought that should be satisfied prior to the final plat on phase 2. There's going to be some conditions that don't get satisfied until the end of the development, such as the land swap and the traffic calming devices and things like that. But they've been a great development to work with, or developer to work with. This item was going to be presented to on the May council, and staff ended up pulling it after a meeting where we discussed the timelines on when such conditions should be satisfied. Staff thought it was wise to go ahead and get the contribution towards road improvements at South Carroll and Reed. That contribution and that condition was set to be no more than $1,500 per lot. So the Smith Douglas delivered a $270,000 check to the city yesterday. So that was given to the finance department. They have also supplied a bond in the amount of $323,000 for this development, and that is based off linear footage of the infrastructure, among a few other things. So staff is seeking and recommending approval of this final plat phase 2.
Any questions for staff? Any discussion? All right, does anybody have a problem with making that consent number 3?
Thank you.
Okay, thank you. Okay, community development, C1, temporary alcohol, Miss Cox.
Good morning, Whitney Cox, licensing specialist. This item is an application for a temporary limited pouring license from ETA Omega Foundation Incorporated. Their intent is to host a one-day golf tournament located at the Mirror Lake Golf Course, 1000 Canongate Parkway. They want to hold this event on Friday, June the 20th from 7 a.m. to 4 p.m. And a little background on the foundation. It was formed in 1995. It's a nonprofit organization created to advance educational and community programs. It's donated over $500,000 in college scholarships and supported various award-winning mentoring programs for Atlanta area youth. And they did not require any public noticing, so it wouldn't require a public hearing, and staff recommends approval.
Okay, can you give a little more specifics why it doesn't require a public hearing?
Because it's just a one-day
Okay.
temporary pouring permit. Customarily, we haven't required that for any other events of this nature.
Okay.
I think this one's come up every year for the last few years, hasn't it?
This is a different one. They have hosted before. The other one is the Georgia Food Industry Association, the Education Foundation, but it's similar, very similar.
When do we cross over the point of needing a public hearing as far as these liquor license?
Yeah, when they actually need a license to sell or pour on a regular, it's an ongoing business.
Over what period of time makes that option?
More than a one-day event.
Past one day? Okay.
Okay, is there any objection to making this consent number 4? All right,
Thank you.
thank you. TA-04-25 text amendment to modify smoke shops, community development. Mr. Daniels?
Good morning. Sean Daniels, Planning and Zoning Administrator. And this amendment, it was initiated due to the influx of smoke shops, particularly vape shops within the city over the past couple of years. And vape devices are a relatively new business type, and our current city ordinance does not define or regulate such uses. To address this gap, Section 8.22 of the zoning ordinance is being updated to include the relative language. Staff is proposing to increase the required distance between smoke shops and sensitive areas. Once a sensitive area, it's hospitals, parks, schools, things of that nature. So currently our zoning ordinance permits a smoke shop to be within 300 feet, and that's property line to property line from a sensitive group. Staff is proposing to increase that to 1,500 feet, and as well as the city ordinance is also addressing smoke shops and same uses. So if it's an existing smoke shop, currently within our city ordinance, it can't be within 500 feet of a new business coming in. So staff is also proposing to increase that threshold or that proximity to 1,500 feet as well. Staff is also proposing to any business where nicotine or vape-related purchases exceed 25% of aggregate sales will be classified as a smoke or vape shop. Now, the Planning and Zoning Commission did recommend to deviate from staff proposal of the aggregate sale threshold and replace it with any smoke or vape products that is being occupied at least 50% of a business total display area will be qualified as a smoke or vape shop. So, example, if you go into a smoke or vape shop and you look at their merchandise visually, if it exceeds that 50% threshold, then they will be required as a vape shop. And again, that is what Planning and Zoning Commission is proposing. This text amendment is also going to be added some key terms, including vape juice, vape products, vape shops, as well as medical cannabis dispensaries. Now, per Georgia state law, pharmacies may be given a state license dispensing medical cannabis or low THC oil, and businesses does have to adhere to pretty stringent state requirements in order to get that license. This overall text amendment is to better regulate smoke and vape shops within the city, ensuring alignment with existing zoning policies. Thank you.
Does anyone have any questions for staff? Ms. Wormuth?
Sorry, this will be super quick. Just for my understanding, when we talk about not located within a certain amount of feet, how is that measured?
Yes, ma'am. So it's property line and property line, and just to be cognizant, within our current zoning ordinance, these shops, let's say a new smoke shop wants to come in within our city, it can only be in C2 zones. So currently, if we have one inside the Walmart shopping center, if a new one wants to come in, they can't be within property line and property line 1,500 square feet from each other.
So when you mention about Walmart, because obviously that's not a vape shop, because they wouldn't meet the 50% of the display that's mentioned in here. So you're saying that if someone is selling, maybe I missed that in here, if someone is selling, like, let's say a gas station, then how would that include this?
Well, so staff is proposing to have a 25% threshold, and that is with aggregate sales. So let's say a smoke shop, once they come in, if they exceed that 25% aggregate sales, then they will be right off the bat be a smoke or vape shop within the city ordinance. Now, Planning and Zoning Commission is proposing to deviate from that and do the visual 50% of display. So if you do go into a smoke shop and you see, okay, half of their merchandise being displayed is vape or smoke shop related, then they will be classified as a smoke shop within the city.
Is a 50% display for a vape shop, would that become a legal issue?
Yeah, you're catching on to the difficult part of this ordinance, which is defining what a vape shop is. Now, if you go back probably 2 years when we saw kind of a rash of applications for vape shops, they were, in their applications, they were calling themselves a vape shop. So that's easy. It's the gas station that the whole front of the store is selling vape products, but they're selling gas. That becomes the more difficult thing to define, and you can look all over the state. And I think what Sean did was kind of took the industry standard on how to define what that is. But it's a difficult thing, and it's going to be a difficult thing to police. Just like, we don't have bars and we don't have what's called strictly a bar in Villa Rica. You have to sell food, so you have 50% of your sales have to be food. So there has to be some mechanism for policing when you put regulations on shelf space or percentage of sales. Some of this is going to be in the application process that they're going to have to tell us what they're doing. But if they've applied to be just a convenience store and we walk in there and all they're selling is vape products, then they're probably going to get a citation of some kind.
So in your opinion, does this cover, like the changes to this ordinance, does that cover what you're referring to?
I think it's the best that we can do, really. We had a couple clear objectives in this ordinance. One was to keep these type of businesses from your historical downtown area. So I think it does that. We hadn't dealt with medical cannabis dispensaries at all, but that's kind of a new thing, and it's heavily regulated on the state level. So we're basically saying that whatever the state regulations are our regulations. So if you violate the state regulations, you're violating our ordinance, and we can punish you for that. But it keeps, based on this, you shouldn't see somebody put in a smoke shop or a vape shop across the street.
Okay, I don't see how the 50% display is going to work, because they could scatter this stuff all over the store. And how are you going to decide if that's 50%?
Policing is going to be a challenge no matter how we define it. So, but
the amount of sales related to vape equipment might be a more reliable way of determining.
Yeah.
Okay, and Mr. Montana.
Well, but to Danny, I don't know. I know, like, when it comes to, it's kind of what Danny was talking about there. I know when it comes to like restaurants and stuff, I think the city is allowed to review their gross sales and stuff. I don't know if we're allowed to initially do that for a convenience store. So it may actually be easier just to be able to have a code enforcement officer walk into it and say, well, only this row is vape stuff and everything else is chips, candies, and Cokes. So that's less than 50%. So that, visually, it might just be easier to look at that. But my question actually, and I think Kevin and Sean, you may have kind of addressed this, but on the medical marijuana part, so are you saying, or the medical cannabis dispensaries, so only a pharmacist can do that?
Well, they have to get a state license to sell it.
Okay,
and it's a huge investment.
So I guess my question is then, why would we not want to limit the medical marijuana dispensaries to just the C2 zone like everything else in here? Or is that covered by statute?
It's covered by state law, and
okay.
I think, at least the way it's structured now, there were about 6 bills introduced last session that would have changed this, so it's a changing area of the law.
Mm-hmm.
It's a developing area of the law. but this could be a CVS or,
Right.
you know, that we don't, the way it's defined now and the type of investment, it's not going to look or feel like a smoke shop or a vape shop. It's going to feel more like a pharmacy.
Okay.
So I don't think we have the same concerns with
As we would.
that we.
Because
do
it's
with
in
the
a
other uses.
pharmacy setting, at least currently by state statute.
Right.
Okay.
Now, but if you've been out west in the last couple of years.
Yes.
You
Yes.
know, we could end up in that situation, and we probably want to revisit if we
Yeah,
get to
we
that.
visited Branson, Missouri back in March, and every corner had a medical marijuana dispensary.
Yeah.
They were huge, massive buildings. You would have thought it was a CVS.
Yeah, I was in
And it just
Montana
said-
last summer in an Airbnb, and 3 sides of the Airbnb were marijuana dispensaries.
Hmm. My only other thing is when we're kind of listing and 2A has urgent care. I think that was an added term. I think there should be a comma between urgent care and hospital, because hospital has a certain definition under state law, and obviously urgent care facility is not a hospital. So that was my only other one. Thank you.
Any more discussion? Ms. Warmoth?
I'm sorry. So, to Danny's point, I kind of agree as far as the sales. So why would we not go the route of the amount of sales versus the display? Because visually speaking, I could open up a vape shop and only have the small display and hidden with chips and drinks and everything else. But most of my sales are going towards these items versus these items. It almost feels like it could be easily hidden as I'm opening up a vape shop, but I've got lots of drinks and chips and stuff for the kids over here. So I almost feel, I think that was a really valid point to bring up. I almost feel like the amount of sales is what would matter more so than the amount of display.
Yes, and staff is proposing the 25% threshold for aggregate sales. And Planning and Zoning Commission, they deviated for what we're proposing, and they went ahead and tried to propose for the display.
So we could just leave out the 50% display part and just leave.
Those are alternatives.
I see now. The blue,
Oh.
okay, the blue is the letter from the planning commission. I see your key now.
I'm so
Okay.
sorry. I was
see.
very confused by how that was written then.
That's alternative text.
Yeah, it kept
I'm not
it-
colorblind.
Similar debate, I think, that was in P and Z.
I guess my only question then is, I know like with the restaurants, the city can do an audit and find out, well, how many of your sales were alcohol and how much was food. Do we have that ability to do that to any other business?
I think
whether
so.
it's,
Yeah, because it's a licensing issue.
Okay, well, I guess in that case, then I'm fine with the sales then. I just didn't know we had that authority to do that.
Right. I agree.
Yeah, I think visually it's too subjective. Depends on who's doing the viewing, so how much they think it is. So I think we lock it in on numbers, we're much better off.
It's better to have something quantitative that you can
Yeah.
easily measure, in my opinion. All right, does anybody have a problem with making this
Well,
consent?
real quick, I'm sorry, so
Oh, public hearing, all right.
we need a public hearing on this? Oh. Well, real quick, I guess, do we need to put something in here that says that the city reserves the right to audit
Yeah,
sales
I
or
think
something?
it might be a good idea, and Sean and I can work on an additional sentence, paragraph.
All right, thank you. Thank you, Mayor Pro Tem.
I was hoping to get through this with only like one item, everything else put on consent, but this has a public hearing.
This does require public hearing.
This requires a public hearing. Okay. D1, Human Resources. Thank you, Sean.
Good morning, Tiffany Lamford, HR Director. I am presenting our workers' comp renewal. This policy ends June 30th and the new one will begin July 1st. We're remaining with the Mallory Agency as our broker and with Bitco as the carrier. They continue to underwrite us every year at really good rates despite having to cover a police department, and our premium this year decreased by $6,500. And they've been a great company to work with. And I have Jason here from the Mallory Agency if you have any questions pertaining to the specific rates.
Okay, do we have any questions for Tiffany or Jason?
No questions, but I really like the direction you're headed, downhill.
Yes,
That's good.
me too.
So does anybody have a problem making this consent number 5? All right, this is consent number 5.
Thank you.
Thank you. E1, Public Works.
Good morning, Hale Birch, Director of Public Works. What I'm bringing before you today is the adoption of the Georgia Department of Transportation Title VI Non-Discrimination Agreement. As part of our LAP, or Locally Administrative Projects, certification and qualification to receive federal funds, the city must adopt, or is required to adopt, the Title VI Non-Discrimination Agreement. The background: the City of Villa Rica, hereinafter referred to as the recipient, assures that no person shall, on the grounds of race, color, national origin, as provided by the Title VI of the Civil Rights Act of 1964 and the Civil Rights Restoration Act of 1987, be excluded from participation in, be denied the benefits of, or otherwise be subjected to discrimination under any program or activity. The recipient further assures that every effort will be made to ensure non-discrimination in all of its programs and activities, whether those programs and activities are federally funded or not. This is more of a formality, obviously, that we assure that in our projects that we will not discriminate against contractors or businesses that would have that we would not discriminate against them. Excuse me. So obviously our recommendation would be to adopt the Title VI Non-Discrimination Agreement.
Does anyone have any questions for staff?
No questions, but it's obviously, this is what I call a no-brainer, because if you don't adopt it, you lose your federal funding.
Correct.
Easy for me.
All right, no discussion. All right, anybody have a problem making this consent number 6? All right, moving on. Thank you. Utilities, Mr. Bain. F1, Developmental Regulations Update.
Good morning. John Bain, Interim Deputy City Manager. This item is to propose and amend Appendix A of our Development Regulations, our Code of Ordinances, Section 1A, Section 200. As we know, as recently as last month, we made a revision to our developmental regulations, which now require the production of an availability letter from the Water and Wastewater Utilities Department in order to receive capacity for annexation, any applications for annexation, rezoning, special use permits, building permits, land disturbance permits, or approve any residential construction or any commercial development. So those letters of availability are required prior to doing any of that. While that inclusion was necessary, staff has since identified an opportunity to make the process a little more efficient for our residents, requiring a couple specific approvals. Those two approvals that we currently require this letter that we are looking to amend are for home occupation with 2 or fewer employees, as well as the construction of a single-family residential unit on a single parcel. So attached with this are the proposed exemptions highlighted in blue under Section A of the Utility Availability Statement, which is under Section 200. So exemption 1 is a home occupation business license request employing no more than 2 individuals are exempt from the requirement unless the business, in the opinion of staff, constitutes a significant impact on the water and sewer utility conveyance and or treatment system. Item number 2, 1 single-family residential unit to be constructed on 1 parcel that is currently vacant is exempt from this requirement. So essentially, staff went back and looked at these 2 requirements, these 2 applications that would currently require a letter of availability, and we determined that in most cases these do not necessarily impact the water and wastewater utility to any extent that would cause us to want to prohibit the construction of a single-family home or the production of a business license for a home occupation. As oftentimes those home occupations rarely constitute an increase in demand on the water and sewer utility, whether it's a home landscaping business, home woodworking business, any home business like that, unless you have more than 2 employees, and we put 2 employees because that falls under a different requirement in terms of business licenses. So we held that to 2 employees. And then the other item is we would like to provide some relief for someone who owns a single piece of land within the city limits that would like to build their home on that single piece of land. We feel like just in terms of principle that that's the right thing to do, is to allow that home to be constructed.
Any questions for staff?
Just one on that single family residence. I mean, if you have a subdivision going in, you can put one house on
Right.
one piece of raw property. And how does that avoid them taking them one by one, getting the whole thing approved?
Any residential development doesn't fall under these exemptions. This is for we have one neighborhood, for example, that has one undeveloped piece of property. The property owner would like to build a single-family residential unit on that last remaining parcel of that property.
I can understand where your intent is.
Yes.
To help one person out that wants to build a home on a piece of property. But it seems to me like it opens the door for someone that's going to do a development.
With the development, everything would have to be approved prior. All the underground infrastructure would have to be in place. Right. The streets, the curbing would all have to be constructed prior. So that would go through a different review process.
So John, what about this scenario though? What if somebody owned 5 acres of land and they wanted to subdivide it into 1 acre parcels? So they come in and they apply for this to subdivide it. City engineer stamps it off. Now they have 5 1-acre parcels. 6 months, a year goes by, and now that 5-acre parcel eats one at a time. Somebody comes in and pulls a permit for each 1-acre parcel. Now you have 5 houses that just got built in a matter of 2, maybe 3 years. I think that's kind of the scenario that Danny is speaking to, is that it's a way to kind of, I mean, technically, what if and I know typically when a subdivision builder is building, they're pulling permits like this, 5, 10 at a time. But if they wanted to circumvent this process, they go in and they say, well, I want to pull a permit for 1 house at a time over the next, I don't know, month, 3 months, or even the next day.
I think Tracy can speak to that. I believe that would have to go through the approval process, correct?
Correct.
Tracy?
So in our planning zoning ordinance and our development regulations, anytime you split a lot over into more than one divided parcel into 2 lots, it becomes a major subdivision. And once you trigger a major subdivision, per se, then you have to go through the whole development process that John's talking about, where that all has to be done on the front end.
You say even if you take just a 2-acre thing and divide it in half, it creates a major?
So if you take it and divide it in half, no, it's a minor subdivision. But once you go over, like you were saying, 2 or 3 lots out of that.
What's the limit? I mean, how far over?
You can just 2. You could only divide it into 2 separate
You can do
lots.
2, but if you go past 2.
It becomes a major subdivision. Yes, sir. And then that triggers that whole thing. And then the ability for, I think, staff to have discretion. I think we're pretty, discerning, like, no, we see this here, and we would make you go through that whole development process, even if, trying to sneak something in. This is more intended for the individual homeowner, that the family's owned this lot for 20 years, and
I guess my only thing, and I understand that, and it's up to staff's discretion, and I understand that.
Yes, sir.
Right, you guys are very discerning, and you can pick up on that.
Yes, sir.
But once somebody comes in, and then they have vested rights, and then they're arguing, no, I have a right to build this because you've approved my subdivision already, and I have a right to override this ordinance. And that's my thought, is that you're just kind of, someone's going to put the pressure on it, and.
Well, yeah, I think what we all discussed and with John and all, and seeing these things coming in to us now under this, is that we're basing this off of that individual single lot.
I understand that's the
Yes.
intent, but what I'm saying is not in the ordinance. And so if it's not in the ordinance, it can be interpreted by something else or worked around.
Yeah,
And that
we-
is exposure to basically saying we're going to set the ordinance aside because it's
Yeah, so
not
if-
explicitly clear. That's my concern.
Yep. So we could add a little bit of language in there, I guess, to that point, John. I mean, that's up to you, but
Yes, we can certainly go back and review it further and try and clarify some points to that. The reasoning for placing it in as it is because under the current development regulations, we will be, based on the regulations and our existing capacities, the answer will essentially be no.
Right. And
to
no, and,
any
and don't get me
homes, right?
wrong.
So-
I totally agree with your
Yeah.
intent is.
Mhm.
I'm totally on board in that, and that's very important to have. And I've had people reach out to me, and they were concerned about this.
Mhm.
What I'm concerned is if the intent is not properly in black and white on this paper, then it can be argued that that's not what the ordinance says, even though that may have been what the spirit of is or the intent was, and then it's used to circumvent with somebody because we're talking about. At least based on the projections that we've had, right, a couple council meetings ago, I mean, we're talking about it could, unless something significant happens and changes, we could be talking about 3 or 4 more years of this situation where this is basically going to prohibit growth. And so what I'm saying is people are going to essentially, at some point, probably going to get tired of waiting, and they're going to find a way to build something in Villa Rica, whether they have to build it one house at a time or not. And I understand the intent here is for an individual homeowner to build their home. I just went through that process a year and a half ago. I know what you're talking about. But what I'm saying is, if you leave it up to the builder developers who want to make an income, they're going to find a way to work their way around
We
this.
can certainly go back
Yeah.
and take a deeper look into this and make sure we have everything covered. You know, initially in our previous amendment that we did, we prohibit essentially anything without that letter of availability. So we wanted to go back and find a solution for that, but
Sure.
it's a good point. If there is, we wouldn't want to, that's a concern of mine from the utility side, is to just get these constant, you know, we can allow one home, but one home can become 30 or 40 across town, right?
Yeah,
All
sure.
these 5-acre lots being subdivided. That is something of concern.
And I
So
think-
we should go back and rework that. I can do that.
And I think and I know we've talked about intent, but this eases up too. So if you have the one homeowner or the one lot, single lot, and we allow that without this language in there, like common sense, okay, there's this one lot here, and we allow this without them going through all that, without this ordinance change, I think it opens another Pandora's
Right.
box where they say, well, you let that, and that's what we're trying to avoid
Sure.
too. And as far as subdivisions that already have been developed and say there is 4 or 5 lots left into that, and I think that's the big concern here. To me, now, I'm not an attorney, but they've got vested rights already. In other words, they've already got,
Yeah,
they
got
may not have
platted.
bought a meter, but they've
Right.
got a tap there, and they've got a box there for their meters. And even if that person came in and bought one lot at a time, I think they still have that vested right. So it's not nothing new that's coming into the system that we don't already have on
Right.
that paperwork. But John is a whiz at fixing all this. He can put that language in there. But that
Well, I mean,
was the intent
I mean,
of it.
maybe it's something that you catch it at that subdivision when they come in and they say, I want to divide this, and well, you put them on notice then that they have to, because now it looks like this is a major subdivision, you know.
Yeah, absolutely.
Now it has to be, and then you tell them they have to, because it's not just one homeowner, but,
Yeah.
you know, maybe I'm overthinking this. I don't know, but I just kind of feel like this creates a workaround, and I understand the intent, and I agree with the intent. I just want to make sure that the intent is carried through and not manipulated, basically.
Yes, sir.
Does the current ordinance already give you, I mean, it gives you the option of waiving it and allowing someone to proceed? I believe we gave you that authority to.
The ordinance essentially is centered around percentage of capacity. There is a remedy, though, if staff determines that we do not have capacity, and the remedy is an appeal process to council.
So actually, they still have to get your approval before they start putting a house on a lot.
Yeah, my approval or
We
council.
have it already approved, yeah.
Yes, sir, my approval or council's approval.
Yeah.
Yes.
So, seems to me like we're covered already. They still can't proceed to put a house on it unless we approve it.
Sure. Yeah, we were trying to accomplish two things here. We were trying to offer some relief for someone looking for a home occupation because those applications would tend to back up with our community development team. So we're trying to offer some relief for our residents as well as our staff there. And then we're trying to offer some relief for someone wanting to build a home. But they're very valid points, and we do have concern about someone trying to, for lack of a better term, nickel and dime every step of the way. And next thing we know, we have someone owns a 20-acre parcel, has 20 homes they're constructing on it, and essentially a de facto subdivision.
Yeah,
we want to prevent that, certainly. So
I've seen this happen a lot. I even saw it out on Edge Road where they divided up into pieces.
Yes.
And sell them individually, and before long you got a small subdivision.
I think it'd be worth going back through the process again, reading through this again, and reading through our recommendations and making sure we have everything covered we need to cover that can still offer some relief for someone wanting to build a home in their land.
Okay, any other discussion? All right, we're moving on to G1, City Manager, so I guess that's you too.
Yes, ma'am. So this next item is proposing a resolution declaring municipal property as surplus and authorizing the disposition and sale of the property. This property is Lot 6 on Russell Street, VR 27-V050180066. So it's my understanding Diana had previously been working with Habitat for Humanity on this particular lot, which is 0.26 acres. She has, I think, through communications with Kevin, correct? There was conversation between Jennifer and Kevin on this lot, and attached with the packet is an aerial from Q Public on the specific lot in question, and there's also a proposed resolution attached. I believe we felt it necessary to provide this resolution before moving forward with Habitat for Humanity.
Yeah, the city originally got this parcel from the county. The taxes weren't paid, and it went through the tax assessor's office, and the county ended up with the property because taxes weren't paid, and at some point in the past, they ended up giving it to the city. And it's sat vacant since then. Diana had been talking with Habitat for Humanity. They're looking for a place to build a house in Villa Rica. We haven't figured out exactly whether we can do that or not without some type of sale. And the first step in that process is to sell it, or to get rid of it, period. We have to declare it as surplus. So the city has no use for this property at this point. So we'd like to declare it as surplus. We may still have to go through the competitive sales process, and Habitat may have to buy it and compete with other potential buyers in buying it. But to even to get to that process, we have to declare it surplus.
So Habitat is still interested in this project.
Yeah,
Okay.
they would purchase it, I think.
Okay.
But they may have to compete against other potential
Others,
buyers.
yeah. Okay. That's why I was curious about what happened with that, so thank you.
Okay, any other questions for staff? Any discussion?
And I think they're teaming up with Southwire. Maybe Southwire is going to pay for the house, I believe.
Any discussion? All right, can we make, this doesn't have a public hearing or anything, can we make this consent number 7?
Do we need to read this resolution, or?
Kevin?
Yeah, it wouldn't hurt to read it.
Okay. A resolution declaring as surplus and authorizing the disposition and sale of certain municipal property located at Russell Street, V-Lot 6, Russell Street, VR 27, parcel number V V050180066, author quitclaim deed, and other conveyance or property documents required to effectuate. Do I have that word right, Kevin? Effectuate same, providing for an effective date and for other purposes. Whereas the city of Villa Rica, the city owns certain property located at Russell Street. I'm just going to do the parcel number V050180066. Whereas the city finds it in the best interest of the city to declare as surplus and dispose of said property as said property is not serviceable for city purposes, and to convey the property for development as low-income housing. Be it therefore resolved by the mayor and council for the city of Villa Rica that it hereby declares as surplus that certain property located at Russell Street, parcel number V050180066, as shown in the attached tax map, and authorizes the city manager and the city attorney to proceed with the statutory procedures for the proper disposition and sale of said property, subject to including a condition in the sealed bid process requiring the bid to include a plan to develop the property for low-income housing. So resolved and effective the 10th day of June 2025. So anybody, can we make this consent number 7?
Yeah.
All right. Before we go into executive session, I'm going to read off the consents. And if I missed something, please let me know. Consent number 1, making July Parks and Recreation Month. Consent number 2, planning and zoning appointment for Ward 2. Consent number 3, I thought you were going to do that Tuesday. Consent number 3, Jameson Towns Phase 2 final plat. Consent number 4, temporary limited alcohol pouring license for ETA Omega Foundation, Inc. Consent number 5, the 2025-2026 workers' compensation renewal. Consent number 6, adoption of GDOT Title 6 non-discrimination agreement. And consent number 7, resolution declaring municipal property as surplus and authorizing the disposition and sale of the property located at Russell Street. Does anybody have any? All right. So Kevin, can you?
Right, if we can have them go into executive session at this time for the purpose of discussing, deliberating upon appointment, compensation, hiring, disciplinary action, or dismissal, or rating of a public officer or employee.
Okay, this is not a voting meeting. Do we have to vote on that?
Yeah, just for the purposes of this.
Okay, I'll make that motion.
Second.
All in favor? That's unanimous.